Hi folks, my name is Greg McLawsen. I am the Affidavit of Support lawyer. My practice focuses on helping green card holders enforce the Form I-864 Affidavit of Support in federal lawsuits. One of the very first questions I get from most clients I work with is, how often am I going to have to go to court? A lot of my folks have come through contentious divorce proceedings, and they are often in no big hurry to head back to the courthouse. In most lawsuits that I handle, my client actually never has to go to court a single time. We can talk about why that is, but the bottom line is that in most Affidavit of Support lawsuits, you might not have to go to court at all. At the very most, you might have to go once or twice. So in the federal system, unlike divorce proceedings that you might be familiar with, most parties don't have to go to court very often to argue what are called motions. Motions are any time you ask the court to enter an order. You might be familiar from family court proceedings where it seems like you're going in practically every week to deal with custody issues or ask for temporary alimony. And it's not like that in the federal proceedings. Most times that we have to file motions, even very complicated motions, those are typically decided on the papers alone, meaning that even the attorneys don't go to court to argue. But even in Affidavit of Support cases, when you do have a motion that gets argued to the judge, it's typically only the attorneys who show up to do that. And these days with COVID, more likely than not, that's going to be a Zoom proceeding anyway. There are a few exceptions that could involve the court asking the client to come to court. One situation, and this is probably the thing we see most often, is that courts can, and usually do, require the parties to show up if there's going to be a mediation. Mediation is where you go in front of a magistrate judge and try to get the case settled. As I've discussed in other videos, most I-864 claims end in settlement agreements, and that's a great thing. The best for both parties is if you can avoid court and work things out like adults. So if a magistrate judge, for example, is going to be involved in a settlement conference, it's very likely that the magistrate is going to want the client there because it's important to have settlement authority and not just have the attorneys argue. If that happens, it's very common that the judge will have the parties separated in different conference rooms. So it's not likely to be the case that you as the plaintiff are sitting across the conference table from your defendant. So especially in cases that involve high conflict, if there's a history of abuse on the behalf of the U.S. citizen, that's something that we can communicate to the magistrate judge in advance, and they can usually arrange it so that the parties don't even see each other, but are separated into different conference rooms. Another situation where an in-person appearance can be required is if a deposition is taken. You can think of this as basically a formal interview that's used for purposes of gathering information about a case. Most Affidavit of Support claims tend to get settled before they go into what's called the discovery phase, which is the formal exchange of information between parties. But sometimes they do proceed into that, and if that goes forward, the defense can ask to take a deposition of the plaintiff. This is an interview that's conducted by the defense attorney, not by the defendant himself, unless he's self-represented, and you would have me as your attorney there present for the deposition. It's relatively rare that cases get to the deposition phase, but it is possible. Lastly, once in a while, an Affidavit of Support claim will go all the way to trial. This is pretty unusual. Usually, even if the defense is completely unwilling to settle, these cases are typically resolved at something called the summary judgment phase. This is when we go to the judge and say, "Judge, there's no reason to have a trial on this case because the facts are not actually in contention. We can show that the Affidavit of Support was signed. We can show what our client's income is. And based on those facts alone, we are entitled to judgment." But in rare cases, it will proceed all the way to trial. This happens maybe once a year or so. And in that case, of course, the parties would both be required to show up in person. But again, in the vast majority of cases, the plaintiff, my client, the Affidavit of Support beneficiary, does not actually end up needing to go to court. And if an in-person appearance is required, it tends to be very limited and only for 1 or 2 times in the entire case lifecycle. So I hope that is some comfort that if you are considering a lawsuit under the affidavit and you're concerned about having to show up for court, that's probably not going to be an important reason to avoid the litigation. Because again, in most cases, the plaintiff will not be required to show up in person in court. I hope that's helpful. If you have questions, feel free to drop them in the comments. If you're interested in a confidential case assessment of your potential rights under the Affidavit of Support, reach out to us on our website. We do free video consultations all across the United States.